overturn themselves. I have a case now in which the same judges have given different rulings but coming to the same results, all on the same statute, but now being maybe not intentional, so result-oriented that the judgments are equally corrupt. Not because the judges are corrupt, but because there is a manpower shortage which requires them to not spend enough time with the records of appeal either. And so you have a situation where you can spend a lot of time, and if they're impatient with you, you will not even be able to convince them that their first impression of a case is off by a mile. And that you ought, in fact, to be given the opportunity to develop your case as you would. And this is more the case in the appellate court because they seem to form views. I've had a situation where, and I use this as an example, I'm in court sitting down one day in the Court of Appeal on a different matter. And an indigent, an obvious indigent comes in and he is shackled and he's shuffling. And he is in his hands, there's some paper, and you have a bench that comprises a Bahamian judge, a Jamaican judge who was then presiding, and then I think a Trinidadian. And here was the challenge for the young man, because he has no counsel now. And they're trying to convince him. He doesn't even know what they're saying because the Jamaican judge is talking to him in Jamaican dialect. I have a difficulty with that myself. I'm sitting there. And they're saying, well, Mr. So-and-so, you have no case. We cannot see how you have any basis for an appeal. I'm parroting them now. And I'm saying to myself, if he has no assistant, this is a serious charge. He's been sentenced to the court below to 18 years in jail. Young man. So I rise and I said, would you permit me as an officer of the court just to make one observation? Meanwhile, now Justice, Chief Justice, he was then on the appellate court, and I had to say, but you know, I would have thought that a certain section under the Court of Appeal Act applies here. This charge is serious enough that he ought in fact to have representation. It's a criminal charge. And what do you mean when you say that you have not been able to make out a good appeal? Who has assisted you in that? Who has assisted him in trying to convince you that you're wrong? And I think they were embarrassed because when they looked at it, they saw there was a provision. And suddenly, the Bahamian judge realizes this is where he's being overwhelmed by foreigners. Not because they are bullies, but because he lacks the courage to say to them, you are the visitors here. I've practiced in this country as Solicitor General. I've practiced as a judge on the Supreme Court, and I know my way about this farm. You have just come here.
Yes.
And they would have been grateful for the assistance rather than being embarrassed. So they look at the provision, and suddenly it dawned on them. So they called the AG's office, who was their prosecutor. They said, well, can we have an adjournment? And would you allow him to get some representation? The short part of the story. He got representation, and he was acquitted. In fact, it was found that in fact he was not even guilty of the charge. Here was a young man who was likely to spend 18 years, except for what is rebated. Can't speak English, doesn't understand the rules of the game. It's a treadmill. And why is that? Because the judges must move on to the next case. They must move on to the next case. Nothing personal. It's all institutional. And so you begin to institutionalize bad practices. Practices which at the end discredit you as an individual, discredit the institution in terms of what is expected of it. Normally, but which in fact continues to fail in terms of that expectation. Because you cannot get it right. You will not get it right. And when you do get a judgment right, It's all by mistake. It's happenstance. You cannot explain it to me, and it will not stand the test. It will not stand the test. Why? Lack of institutional memory. No ability to recall. And in the instance of some of the more senior lawyers, they have no reason to help the court to recall because they have become result-oriented as well. And if they play the game well, they will get the results that they want for themselves and their clients. And in that regard, we're being deceitful. And we're betraying not only ourselves as professionals, but we're being bastards in the face of that which nourishes us.
I have a question.
Actually, if I may, she was first.
Well, I was on the institutional memory question. Why is it we don't have, are you suggesting that it's because the standard of practice before the bar is not up to the standard to enhance and cherish this memory and advance it? Or what are you, why don't we have it? I mean, what happened to it? I know that exists in other countries. For sure it exists, and we have a long tradition here of British law on which you all supposedly are referred to the for your love.
Precedent. I mean,
what happened to this, and why?
It has disappeared. It has disappeared along with the, how shall I put it now, the sincerity of judges themselves. The judges we bring here understand one thing, that when they come, at the end of that contract, there's the potential for gratuity and a pension. And if they're lucky, they will have a pension here from this government and one from wherever they came from. In fact, we had one judge, in fact, he's still around. Last time I heard he was up in Turks and Caicos. He's about 80 years of age. He goes from jurisdiction to jurisdiction, hardly ever writing a judgment, but collecting pensions. And it's become bad. It's become really disgusting. We don't have it because it serves no purpose.
All right, Maurice, what are we talking about here? You're talking about the love of the law. If these people are here for their pensions or for their whatever it is, the financial side of it, they're not here for the fame and the glory. What happened to their love of the law? Why did they become lawyers in the first place?
Because the law that they must practice, and which they would have practiced as young men in the towns where they were born and in the communities where they were reared, they don't have to demonstrate it here. They have been essentially engrafted on us, but only for short periods by contract. They don't have to care because they do not recognize the name East Street and Shirley Street and Collins Avenue. It's of judges, you know. They work silently and they work slavishly in what they do. But if you have too many of them, they will become a political force in themselves. United States Supreme Court is a political force in itself. The House of Lords, a political force in itself. Our Supreme Court,
As it's supposed to be.
yeah, that's how it's supposed to be. A politically accountable judiciary. You have to be able, as a judge, to say on any given day, I think I'm going to go down to Charlie's and have me a ginger ale. And it doesn't matter that I am a judge. I should be able to mix with people who I know all the time. What is the problem with that? And wouldn't it also be better if, as I go along my daily walks along Bay Street, I love coming to Nassau for that, you know, I'm old enough where everybody remembers me. And they don't mind seeing me because I'm not yet begging them. I imagine that if I was destitute, they might not want to see me as often. But I understand what it's like to be part of this community in a way that no foreign judge ever can.
They wouldn't, never.
They can never do so.